welcome to our video session. In this video, we'll be discussing bars to sponsorship, meaning things that will prevent you from sponsoring your spouse. Okay, there are a list here, and there's about 9 things that I'll mention in this video that will bar you from sponsoring your spouse, common law partner, or conjugal partner. The first one is if you've been sponsored as a spouse or common law partner in the last 3 years, which means if you have been sponsored yourself by another individual and 3 years have not elapsed yet, then you cannot sponsor your next partner. You've received social assistance for any other reason but disability, which means if you're if you're currently on social assistance, then you cannot file for sponsorship. However, if you were on social assistance and you are no longer on social assistance and you're working, then definitely you can file a spousal sponsorship application. If you are on default with an undertaking, so let's say if you've sponsored someone else, part of that undertaking is that you will provide accommodations and so forth, and should your relationship let's say break through and your partner goes on social assistance, and for that undertaking you're responsible for the duration of that undertaking for the person that you sponsored. So if you're on default in that undertaking, meaning you're not paying back the government the money that your partner is currently taking based on being on social assistance, then you're on default for that undertaking, and therefore you cannot sponsor your next partner. Obviously things like immigration loans, so if you received immigration loans for transportation, assistance, the right of permanent residence fee and so forth, you have to pay the government back, and if you don't, then you cannot sponsor your next partner. If for family support is another reason, so being given a court order to do child support, for example, and being in default on that child support, you may not be eligible for sponsoring your spouse. However, if you are under court order and you are compliant with that child support and you continue to pay that child support, then you can definitely file for a sponsorship for your spouse. If you've claimed bankruptcy and your bankruptcy has not been discharged yet, then you cannot file a sponsorship, so that would bar you from sponsoring your partner. However, if you did claim bankruptcy and it has been fully discharged, then you can proceed with filing an application. If you were convicted of a violent crime, and this is very key, the word violent crime, and this includes crimes of sexual nature, or offenses against the relative that resulted in bodily harm. So I'll just clarify this. So if you were convicted of an offense such as DUI, so drinking while impaired or drinking and driving, then that will qualify you to continue with the sponsorship. However, if the offense you were convicted of was of a sexual nature, or if it was violent towards that particular relative that you're trying to sponsor to Canada, so in this case your spouse, then you cannot file for sponsorship. So I'll just repeat that. Either the bar of sponsorship applies if 1, the offense is of a sexual nature, 2, or the person you're trying to sponsor, in this case your spouse, you were convicted of an offense that was violent in nature and it caused bodily harm. So that's the key for when we say violent crimes. If you were previously sponsored yourself and you became permanent residents and not 5 years have passed since that time. So you were previously sponsored as a spouse, common law, or conjugal partner, and became permanent residents less than 5 years ago. So after 5 years, you can sponsor, your partner. Obviously, if you're currently under a removal order, and let's say you're a permanent resident and you want to file spousal sponsorship application for your partner, but you currently yourself are under removal order, then that bars you from filing a sponsorship application. Or if you've been detained in a jail or prison and you're currently there, obviously you cannot. If you were imprisoned and you are no longer in prison, you may be eligible to file that sponsorship. So that it's about being in prison presently at the time of filing the application that bars you from sponsorship. But if you were in prison or there was a jail time served for a crime, and you want to now afterwards, after getting out of jail, file a sponsorship, you may be eligible for that. So you want to contact us and just clarify that point specific to your situation. And the last point that I want to make is if you filed a sponsorship and the decision has not been rendered yet, then of course you cannot file another application hoping to expedite it. So for example, some clients say, can I file an inland application as well as an overseas spousal sponsorship application, and whichever one makes a decision sooner, well, I'll go with that one. That's not how it works. You have to decide before filing if you're going to do an inland or an overseas application. There's a specific video that I did that speaks to benefits, pros and cons of inland versus overseas filing. I hope that helped. If there's any further question, feel free to contact us. Thanks again for joining me.